Natural justice is an important concept in administrative law. In the word of Marguerite Justice, it is justice that is simple and elementary, as distinct from justice that is complex, sophisticated, and technical. The principle of natural justice or the fundamental rules of procedure for administrative action are neither fixed nor prescribed in any code. They are better known than described and easier proclaimed than defined. Natural justice has meant many things to many writers, lawyers, and systems of law. It has many colors, shades, many forms, shapes. According to D. Smith, the term natural justice expresses the close relationship between the common law and the moral principle, and it has an impressive ancestry. It is also known as substantial justice, fundamental justice, universal justice, or fair play in action. It is a great humanizing principle intended to invest law with fairness, to secure justice, and to prevent miscarriage of justice. In Wise Man versus Bony Man, it is observed the conception of natural justice should at all stages is guided those who discharge judicial function is not merely an acceptable but is an essential part of philosophy of law. Definition: it is not possible to define precisely and scientifically the expression natural justice. Though highly attractive and potential, it is a vague, ambitious concept and having been criticized as sadly lacking in precision and has been recognized more than once in the lumber room. It is confused and unwarranted concept and encroaches in the field of ethics. Though element judges have and time used the phrase principle of natural justice, even now the concept differs widely in countries usually described as civilized. It is true that the concept of natural justice is not very clear and therefore it is not possible to define it. Yet, the principle of natural justice are accepted and enforced. In reply of the aforesaid criticism against the natural justice, Lord Reid, in a historical decision of Reid versus Baldwin, observed, the modern times opinion have sometimes been expressed to the effect of natural justice is so vague as to be practically meaningless, but I would regard this as tainted by the perennial fallacy that because some things cannot be cut, dried, or nicely weighted or measured, therefore it does not exist. The term natural justice expresses the close relationship between the common law and the moral principle and described what is right and what is wrong. It has an impressive history. It has been recognized from the earliest time. It is not judge-made law. The, the days bygone, the Greek had adopted the principle that no man should be condemned unheard. The historical and philosophical foundation of the English concept of natural justice may be insecure, nevertheless, they are worthy of preservation. The rules of natural justice were placed so high that it was declared that no human law are of any validity contrary to this, and that a court of law could disregard an act of parliament if it is contrary to natural law. The origin and development of equity in England owed much to natural law. The concept of natural law and natural right influenced the drafting of the Constitution of the USA. It has also provided a basis for international law and international convention, covenant, declaration, etc.